14A District Court for County of Washington, State of Michigan is now in session. All those having business for the court draw near. The Honorable Judge Dave Simpson preside.
You may be seated. Before we begin, I need somebody from the prosecutor's office to put on the waiver.
Gary Keselowski for the people. Although we don't believe there to be the Washington County Prosecutor's Office does not believe there to be any conflict of interest between this honorable court and the prosecutor's office, we would waive any possible or imagined conflict of interest for purposes of today's court hearings.
Good morning.
Wow, you were just gonna go on, weren't you? No, you got it all. No, you were working. That was okay. Mr. Brown.
I like to imagine. Lauren Brown, Deputy Chief Public Defender. Good morning. We likewise do not believe there's any conflict in this honorable court hearing these matters. If a conflict were to arise, we'd waive such conflict so that this honorable court could hear these matters.
And the court, for its part, also does not believe there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case, the People's State of Michigan versus Dustin Duncan.
Ready and then ready.
Kenneth Water, Assistant Prosecuting Attorney. People.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Duncan, who approaches the podium. Mr. Duncan, please state your name for the record.
Dustin Duncan.
Thank you.
Your Honor, Mr. Brown is ready to proceed, but the people are not.
We would move for dismissal here.
People being unable to proceed. This case is dismissed on the defendant's motion. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the People versus Jamison Napier.
Kenneth Water, Assistant Prosecuting Attorney for the people.
And Wilson Tanner appearing with and on behalf of Jamison Napier. Your Honor, Mr. Napier we are ready to proceed with the preliminary exam. I understand, well.
Your Honor, the prosecution would be moving to adjourn this matter for two reasons. First of all, I was informed late Friday that the victim in the case resides in Florida, so I would need to file a motion to allow him to appear by Zoom. This was the first I was made aware of that, but additionally,
But it isn't the first your office is made aware of that.
I can only speak to what I was aware of, Your Honor. I understand.
Well, you got to speak to more than that, Mr. Water. If at the time that this was set, back on September 18th, quite frankly, that had to be, somebody had to know that, only because of and I can go back and find out, but because of the date that I set it for. Because normally this would have been set at the end of September, and there were an additional 2 weeks given for the preliminary examination.
I understand. Additionally, Your Honor, I would point out that there are 3 additional witnesses the defense has advised they would like us to talk to. One of the witnesses is mentioned in the police report, but he, according to the report, refused to speak to the officer. I'm told that now this person is willing to speak to us. Additionally, Mr. Tanner brought another witness who was not listed in the police report. I did have the opportunity to speak.
Inside the 14A District Court, tension filled the air as the judge called the first case of the morning. Lawyers stood firm, each representing justice in their own way. But as the words "case dismissed" echoed through the room, a quiet realization spread. Sometimes the fight for truth ends not in verdicts, but in lessons learned.
And today, I'd be asking to adjourn this matter so that the officer in charge can speak to these additional 3 witnesses that counsel wants us to talk to so we can get a more clear view of what actually occurred that night.
I appreciate Mr. Overwater work in this case. I know he just got on the case, but this has been going on for a long time. Normally, I would agree to an adjournment. I think that this case should be dismissed at this time for them to do the investigation that the officers had available to them while it's not listed. Police officers, some of them as didn't make it into the police report. I don't know why they didn't pursue it in the interview. They have the address certainly of at least two of the witnesses where the incident happened, and which happens to be.
You still want to keep going?
And no.
No, you can go ahead.
No, thank you.
No, really, I'm listening intently.
And I mean it. I don't. I asked that this case.
Defendant's motion to dismiss is granted. Case is dismissed without prejudice. They can reauthorize if that's what they want to do.
Thank you, Your Honor.
Thank you. Or calls the cases of the people versus Stephen Grisbeck.
Prosecuting attorney.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Grisbeck.
Kyle Riddle filling in for Attorney of Record Sam Bernstein on behalf of Mr. Grisbeck in the case ending in 1127 with Mr. Grisbeck's permission. Is that correct?
Yep.
Thank you.
And your name?
Mr. Stephen Grisbeck.
I kind of know that we've seen each other over and over again. All right. What are we doing?
Your Honor, we have entered a waiver on all of these matters, and I'll let Mr. Upperwater put the offer on the record.
That is correct, Your Honor. Pursuant to that waiver, the people will agree on case 25F1 1127. Sorry, case number 1, the other FTD charge. He can plead in circuit court to a reduced charge of false pretenses 200 to 1,000. There is no offer currently with regard to the other case of possession of methamphetamine. However, if he chooses to apply for drug treatment court, the people would not oppose his application and would agree to reduce that matter to a use if he were to successfully complete that. If he chooses not to apply for drug treatment court, then that case can be further negotiated in circuit court. The people may consider a deferred prosecution on that matter pursuant to Mr. Grisbeck completing residential treatment. It is my understanding that he would be going to Sacred Heart in the next few days. So that's our primary hope, that he can get into treatment and get into the recovery program.
And that is our understanding of the offer, Your Honor.
That's correct, Judge.
All right. So he's waiving, however.
Correct.
Mr. Grisbeck, is that correct? You're waiving preliminary examination?
Yep. Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution on all of this?
Yes, Your Honor.
All right. For the record, people also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court in the 3 cases on all 4 counts.
Acknowledge receipt of information, Your Honor. Waive formal reading. Stand mute at this time.
Defendant, every waive formal reading, and you go ahead.
As well, Judge. And as to matter 1127, waive formal reading, stand mute.
Defendant, every waive formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in these matters will be set for
October 28th at 1:30 for Judge Cook.
October 28, 2025, 1:30 before Judge Cook.
And if the Honor recovery up to time, we'll get it.
Bond will continue. He hasn't been, I know I signed orders of release, but they haven't gotten you the treatment yet.
I'm supposed to be leaving tomorrow.
Tomorrow?
Yep.
Good. Mr. Grisbeck, good luck to you.
Thank you. Thank you, Your Honor.
Thank you, Judge.
May I approach sign the information?
We'll get him to you in just a second. October 28, 2025.
Oh, nice.
That's 1:30. I don't know why I'm running 9 a.m.
If you, yeah.
The other judges don't require. Yeah.
It's her misdemeanor. I wrote down what the misdemeanor. The one said his plea form in this because his client's in custody. He's gonna sign this as he comes out.
Got it.
Really won't go in this thing. We can get that waiver out of the way.
He's got the plea.
He's got the plea form. This is what.
Last night.
Yeah. You want me to call for it? I didn't want to rush you.
Yeah, no, go ahead. I'm sorry. Thank God they were all stapled. I would have preferred if they were loose and they just went everywhere. Oh. Court does call the case of the people of the state of Michigan versus Jeremiah Sawyer.
Alex Chavalowski for the people.
Ready Judge Torshell Feaster, Assistant Public Defender, on behalf of Mr. Sawyer, who is approaching the podium. Excited to hear.
I understand there's a plea, but I don't form it yet. That the defendant will be pleading no contest to an added count to malicious destruction of building, less than 200. The 93-day offense upon a successful plea to that added count 3. Count 1 and 2 would be. Is there an amended complaint?
Judge, we did have, yeah, sorry.
Yeah.
Sorry, Judge. You did, we're planning to file an amended complaint that this case go on preliminary examination. That being to add a count 2 malicious destruction of building. For plea, or students, just adding count 2 malicious destruction of building, for between $1,000 and $20,000. And we would actually have it gone to preliminary examination, dismiss count 1 outright.
Okay, well, then we'll have to start this way. Mr. Feaster, you acknowledge receipt of the new information?
Yes, Your Honor.
All right. You waive its reading?
As Jeremiah Sawyer faced Judge Simpson, his calm, "Yes, sir," carried the weight of his choices. A man caught between redemption and consequence, pleading no contest to a crime that could send him back behind bars. The courtroom stood still, another reminder that one decision can rewrite a life.
I do, Judge.
And how does your client plead?
He stands mute on the arraignment, Your Honor.
Defendant having waived from a reading standing mute, court will enter not guilty plea as to count 2. All right, and now there's a plea agreement.
Yes, Judge.
In which the defendant would be pleading no contest to an added count 3 of malicious destruction of a building. A 93-day offense. Upon a successful plea, counts 1 and 2 would be dismissed.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Jeremiah Sawyer.
All right. So Sawyer, it is this court's understanding that you're going to be pleading no contest to the charge of malicious destruction of a building under $200. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property, which is damaged. If that's greater than $500, that becomes the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
Let me explain two things about it just to make sure that you understand. The first thing you need to understand is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea.
Civil liability, Your Honor.
All right. So, sir, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Sir.
Any question regarding any of those rights?
No, sir.
You'll see a copy on the podium. Look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes, sir.
All right. Were you on probation or parole at the time of this?
Yes, sir.
All right. Was it probation you were on?
Probation and parole.
Both?
Yes, sir.
Okay. You understand your plea in this case could be considered a violation of your probation and a violation of your parole. You understand that?
Yes, sir.
All right. You understand that if it's considered a violation of your probation, that court could sentence you to the maximum allowable under that other charge, or charges. You understand that?
Say it again.
If it is considered a violation of your probation, the other court that you're on probation to could sentence you to the maximum that's allowable under the other charge or charges that you're on probation for. You understand that?
He's saying that whatever judge has your probation case, they can sentence you if they determine this is a violation. Like we talked about.
Okay. Yeah, yes, sir.
You understand that?
Yes, sir.
All right. You understand with reference to your parole, if it's considered a violation of your parole, that you could be sent back to prison to do the remainder of your term. You understand that?
Yes. What's the chances of that, though?
I don't know how to answer that. I don't know.
I'm saying like this.
Like we talked,
Huh?
like we talked about, it's up to your parole agent, and you said you contact with your agent, and they had a plan for it.
Yeah, but is they gonna like, from your experience, right? Is this like?
He can't give you legal advice.
Huh?
He can't.
You mean my experience on the bench or my experience with parole?
Like from your experience,
Which one you trying to
dealing with
spin
parole?
something on me? I don't. Go ahead. What?
From your experience from dealing with the parolees, right? They be sending them back for stuff like this. This ain't really serious like that, right?
I cannot answer that because I don't know. I don't know what you've been up to. I don't know what you've been doing. I don't know whether they like you.
All right, man. Yeah, we go. Yeah.
Sir, do you understand that?
Yes, sir.
Now, if you want me to, I don't really want to, but if you want me to adjourn it out so you can talk to your parole officer, I'll do that so that you can be absolutely sure what you're doing.
Want to talk to your agent?
I'm gonna go ahead. It's cool.
You're gonna go ahead with that?
I'm gonna just leave in guys' hands. Yeah, it's gonna be good.
You sure?
It all is anyway. All right. So you understand that by entry of your plea, that those two things could happen.
Yes, sir.
And understanding that, do you still wish to enter the plea of no contest?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you in any manner?
No, sir.
You're doing this voluntarily?
Yes, sir.
And of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 25-15008. Any objection to the court having reviewed that report?
No, Judge.
Based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant to be guilty of this offense. Sir, I do have to advise you that if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, and you commit misconduct as defined by the Michigan court rules, any sentence evaluation or agreement the court would no longer be bound by, and you could not withdraw your plea. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
It's all on the record, Judge.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
You have, Judge.
Court will accept the defendant's plea of guilty or no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be. Is this the only thing holding him right now?
I mean, he has a parole hold as a result of this, but just this case, Judge.
Don't I got something sooner, don't I? I have an October day.
We'd appreciate it.
Hello? I have an October day.
You have October 22nd.
Thank you. Yeah. Sentencing will be October 22nd, 2025 at noon.
Thanks. Thank you very much, Judge.
You're welcome. Sir. Bond will continue. Thank you. Oh, they're waiting.
Yeah.
This is Hispanic.
No, it's not. So I have, yeah.
Okay. Is he out? Okay, so you can go ahead and, yeah. Court does call the case of the people of the state of Michigan versus Darnell Taylor.
Good morning, Honorary Tam House, Assistant Prosecutor Trudy Valley.
Assistant Public Defender Ben Dunawith on behalf of Mr. Taylor, who's joining me at the podium now.
Your name, sir?
Darnell Taylor.
All right.
Your Honor, this is the day and time scheduled for a preliminary examination. People are unable to proceed on count 1, the aggravated stalking. Your Honor, we would motion for remand on count 2, telecommunications services malicious use for a domestic relationship, as well as an added count 3, stalking misdemeanor, and then 1 year, up to 5 years of probation and $1,000 fine.
Do I have a new complaint?
No, Your Honor, I'll get it.
Okay. All right.
Your Honor, if the court was inclined to grant the people's request for remand, could we address bond?
Okay. Count 1 is dismissed. I will remand it to, I'll continue as not guilty plea as to count 2. As to count 3, do you waive any further reading, the presentation and reading of the complaint in that matter?
So waived, Your Honor, thank you.
All right, and how does your client plead to that added count 3?
We will stand mute.
Defendant having waived formal reading, standing mute as to count 3, which is stalking. All right. Court will enter a not guilty plea. Pretrial in this matter will be set in the 15th District Court on
October 29th at 10:30 a.m.
October 29, 2025, 10:30?
Yes.
10:30 before Judge Perry. As
Your Honor.
bond.
We'd ask for PR bond, Your Honor. The complaining witness on this particular case has, I believe, failed to appear at court at least 4 times in 2025. So the idea that, they're going to be able to proceed at any point, and this is on other cases, not just on this one, but...
Well, okay.
Right.
Okay. Go ahead.
Well, the idea that they're going to be able to proceed on the remand, I think, is fictional. She never comes to court, so it's being remanded for the only purpose of keeping him in jail. He's being held on something else, but, we think we're going to resolve that before the 29th. So I think the remand serves no other purpose than to incarcerate my client.
What's he being held on?
He has a domestic violence case with the same complaining witness. The facts in this case have resulted in a motion for bond revocation that's up tomorrow with Judge Conlon. Now, we're going to be dealing with these issues and dealing with that case, but on this particular case...
Go ahead.
Well, I view them as separate. I know the court may not. But, you know, we're going to be dealing with the Judge Conlon Circuit Court case. On this particular case, the complaining witness has failed to show up at now 4 preliminary exams by my count in 2025. Okay, and one of them was found over on 27C, but she's literally never testified under oath. You know, there's no injuries on that case either. So we're in a situation where the complaining witness is saying Mr. Taylor's doing some bad things, no question. But she never says that under oath. And he's spending a bunch of time in jail. So we'd ask the court to let him out, let him deal with his cases. You know, I think a no contact order would be sufficient to keep him physically separated.
When is he up on the other case? I guess I'm trying to figure this out because you're saying I'm looking at them together, but they are related to each other in a sense. Go ahead.
It's up tomorrow in and if I may respond.
Yes.
Your Honor, this is a very long history and one of those classic patterns of course of control. The victim not being present today falls right into that. I mean, for this case, he was sending her messages telling her that he was going to cut off his tether and come kill her, messaging her on Facebook, using different numbers. Again, I'll kill you and him, threatening 2 people, not just her. She is continuously being threatened. And as these things continue, and this basis for the violation, it's completely understandable for anyone who's aware of domestic violence dynamics that she's not present here today. And while we cannot proceed today with the felony count, if it comes down to it, we would motion to proceed under 76827. And if that's what we need to do, then we'll go ahead and do it. I don't believe that that's what Mr. Duncan wants us to do, but if that's what needs to happen today, so be it. I guess that's my position. Our concerns about the victim's safety have not lessened. If anything, her not being here today just adds to that concern. So if we need to use the tools that the law allows us to use to protect her, we certainly can. I'll need some moments to prepare for that, but I have no problem doing so.
I think the court already dismissed the felony charge, so I don't believe they would be able to proceed on anything.
Yeah, okay. You to do that?
Your Honor, we'd rather have the remand than them proceed on 27C if that's the question. My position would be that it's already been dismissed though, so I think the court can, you know, make the ruling.
Okay. He had another case that the victim didn't appear, but was able to proceed to the point where it was bound over, correct?
Yes, and I held that exam, Your Honor.
There's been additional.
There's additional information we might want to be able to.
Tana, always, yes, come on. I knew.
When Jameson Napier stood before the court, it wasn't just another hearing. It was a story of delay, confusion, and hidden witnesses. The defense pushed for clarity while the judge's patience thinned. And in that silence, one truth became clear. Justice doesn't wait for excuses. It demands answers.